Most criminal cases are built slowly. Evidence comes in pieces, subpoenas served on banks, search warrants executed at offices, emails pulled from servers, spreadsheets reviewed by forensic accountants. The kind of evidence that takes months to untangle and teams of experts to explain to a jury. But what happened yesterday in federal court was different. An FBI agent testified about evidence that required no interpretation at all, no forensic accounting, no expert breakdowns, because the entire case, every document needed to prove every charge, was sitting inside a safe hidden in the defendant's home office, concealed behind a painting. And when the agent began describing what was inside that safe, the defendant did something I have almost never seen in decades of watching criminal trials. He didn't wait. He didn't consult his attorney. He didn't even let the testimony finish. He turned toward the judge and begged, not asked, not requested, begged. Right there, in the middle of the FBI agent's testimony, he pleaded to cooperate. This trial had already been underway for 2 weeks. It involved alleged financial fraud. Prosecutors accused the defendant of creating shell companies to hide income, move assets offshore, and falsify tax returns over several years. Up until that moment, the government's case was strong, but not airtight. They presented bank records showing suspicious transfers, tax filings with inconsistencies, testimony from accountants who said they raised concerns that were ignored, solid evidence, but the defense had been doing its job. They argued ambiguity, they claimed reliance on professionals, they suggested mistakes rather than intent. And it was working, at least a little. The jury was engaged. Some jurors took detailed notes, others looked skeptical of both sides. It felt like a case that could genuinely go either way. Then the prosecution called Special Agent David Morrison of the FBI. He was sworn in and took the stand. The prosecutor began with routine background questions: his years with the FBI, his experience handling financial crimes, his role in this investigation. Then she asked the turning point question. Agent Morrison, on March 15th of this year, did you execute a search warrant at the defendant's residence? Yes, he answered. She asked what they were searching for. He explained they were looking for financial records tied to the shell companies, documents showing how money moved, who controlled it, and whether the defendant knowingly committed fraud. Then she asked what they found. Agent Morrison said they started in the home office, filing cabinets, desk drawers, computers, hard drives. They found some relevant material, but nothing beyond what had already been obtained through subpoenas. Then one agent noticed something unusual. A painting behind the desk was slightly crooked. When the agent adjusted it, he realized it wasn't just hanging, it was hinged. The painting swung open. Behind it was a wall safe. The courtroom went silent. The prosecutor asked if the safe was opened. Agent Morrison said yes. A specialist was brought in. The safe was opened in about 20 minutes. Then she asked the question that ended the trial. What was inside the safe? The agent paused before answering. Then he began listing the contents. A handwritten ledger documenting every transaction between the shell companies over a 5-year period. A USB drive containing backup copies of the real financial records, not the sanitized versions given to banks or accountants, but the unfiltered data showing where money actually went and why. A folder of correspondence with an attorney in the Cayman Islands discussing how to structure the companies to avoid detection. Another folder containing draft tax returns, early versions with accurate numbers, followed by later drafts showing how those figures were altered before filing. The prosecutor let that sit. Then she asked the key question. Did the records in the safe match the records the defendant provided to authorities? No, the agent said. They were entirely different. The documents in the safe revealed the real scheme. Everything else was a cover story. She asked about the handwriting. The ledger entries were in the defendant's handwriting. confirmed by a handwriting expert. Every entry. She asked if there were notes in the margins. Yes. Handwritten instructions like "do not share this version," final numbers for CPA, and references to offshore routing. Again, all in the defendant's handwriting. That's when the defendant began to unravel. You could see it physically. Rapid breathing, nervous movements, urgent whispers to his attorney. The attorney shook his head, trying to calm him. But the testimony kept coming. The agent described the USB drive, years of detailed financial records meticulously maintained, the kind of records someone keeps when they want total control, and the kind you hide when you know they prove guilt. The prosecutor moved to admit the ledger and USB drive into evidence. The defense objected, arguing the warrant was overly broad and didn't specifically mention a safe. The judge reviewed the warrant language. It authorized a search of the residence for financial records related to the alleged crimes. She ruled that a safe in a home office clearly fell within that scope. The evidence was admitted. Then the prosecutor asked if anything else was found in the safe. Yes. Approximately $400,000 in bundled cash and a second passport issued by another country. The defendant had dual citizenship. That fact had never been disclosed. The agent explained why that mattered. Hidden cash and undisclosed passports are classic indicators of flight risk, signs someone may be preparing to flee if things collapse. On cross-examination, the defense tried damage control. Why didn't the FBI just ask for the documents? The agent said they did, repeatedly. Subpoenas were issued. The defendant claimed many records didn't exist. The safe proved that was false. Could the defendant have forgotten about the contents? The agent didn't hesitate. People don't forget handwritten ledgers detailing years of fraud. They don't forget backup drives of real records. They don't forget $400,000 in cash. Then came the moment no one expected as the judge dismissed the witness. Before the agent could even stand up, the defendant stood. He addressed the judge directly. "Your Honor, I need to cooperate. Please, I'll tell you everything." The judge told him to sit and speak through his attorney. He didn't listen. He raised his voice. "I know where other documents are. I know who else is involved. Please, just let me cooperate now." His attorney grabbed his arm. The defendant pulled away. Then he turned fully toward the bench, dropped to one knee in front of the jury, and begged, "I'll plead guilty. Whatever you want. Just stop this trial." The judge slammed the gavel. She ordered him to sit or be removed. A recess was called. The jury was sent out. When court resumed, the judge explained that cooperation must happen through legal channels, not emotional outbursts during trial. The damage, however, was already done. Legally, here's what happened. The defendant realized the evidence from the safe was unbeatable. The ledger, the drafts, the correspondence, the cash, all direct proof of intent, not circumstantial, not debatable, intent in his own handwriting. And by panicking in front of the jury, he confirmed what the evidence already showed. Cooperation only has value when it comes early, before the government already has everything. Once they have your records, your notes, your backups, your cash, your passport, there's nothing left to trade. To the jury, his breakdown wasn't sympathy-inducing. It was an admission. The defense rested without calling witnesses. What could they say? Closing arguments followed. The prosecutor didn't even mention the outburst. She didn't need to. She simply walked the jury through the evidence from the safe and ended with one sentence. This isn't a complicated financial case. This is a case about a man who knew exactly what he was doing and hid the proof behind a painting. A verdict is expected quickly, and sentencing, given the lies, concealment, and late attempt to cooperate, will likely be severe, possibly 15 to 20 years. The lesson is simple. If you're going to cooperate, do it before the FBI finds the safe. Once they do, it's already over.